Good evening, everyone, and welcome to the Brian Crombie Radio Hour on Saga 960. A gentleman that I know, a lawyer, a very smart arbitrator, litigator, a barrister solicitor, John Campion is his name, wrote a really interesting article about class action lawsuits. And I was down in the United States recently, and you see these class action lawsuit billboards everywhere. I almost thought that class action lawsuits were a thing of the United States. But what John Campion is saying is that is really an important part of the Canadian legal system he's been in part of, and it has changed the legal system. He's talked about a propane explosion that shook Toronto and created a fireball seen in Buffalo, the largest gold mining fraud in the history of mankind in Indonesia, known as Briancrombie Minerals for Nesbitt Burns, international shipping charges for UPS, et cetera, et cetera. So John Campion is here today to talk a little bit about class action lawsuits in Canada. Mr. Campion, welcome to the show, sir.
Thank you very much, Brian.
So
John's just fine.
So tell me, I have this perception that class actions was a U.S. litigation thing, but you're saying it's something that you've been very involved in Canada, and it's really positively impacted the Canadian legal system because people get together and work together to get positive action. Is that the case?
It is. So let me just give you a quick history. It all began in the early 60s in the United States, and it was a procedural mechanism as much as anything else, which developed there. And it went from sort of some states had it, some states, well, it's a federal court process, so they had it across the land. And then they have class actions at the state level as well. But oftentimes they will get, if there's a big event in the United States and it covers off a whole series of states, then those cases get brought together under the federal court to get decided as one big action. In the 1990s, after they'd had 30 years experience in the United States, the Ontario government decided that it would bring forward a class action process. And to do so, it passed an act. Quebec had actually predated us shortly, and BC and Saskatchewan and Manitoba, they all followed on. And so the provincial jurisdiction piece is important. You can actually have a class action in the federal court as well, but the federal court in Canada doesn't have the same jurisdiction as it does in the US. So what we've got are a series of provincial jurisdictions in Canada, most of them, which have class action statutes, which allow individuals who have been harmed in a group to one or more of them can bring the class action on behalf of themselves and on behalf of all of the class members. So I have one case to give you the largest scope where I'm actually acting for the plaintiffs. I'm normally known as the defense counsel, but in this case, I was asked to take on one for 6 million Canadians. Now, if it turns out that let's assume it's $10,000 per person, if those were the damages, that quickly becomes a multi-billion-dollar case. So there are 6.5 million Canadians. There's no doubt the number of people, the companies confirmed it. And the question is, in this particular case, dealing with data, is there a cause of action, and where is it now? And you can see that the scope of something as large as a multi-billion-dollar case has huge impact on the corporations, huge impact on the individuals, although it doesn't amount to a whole lot per person, depending. 10,000 is a lot, 1,000 not so much, depends. And it's brought forward under very strict judicial controls. That's one of the key elements. This is not like any ordinary case where people can just bring them, but you have to get permission to bring it, and it's under the control of a class action judge throughout the entire piece.
Now, I think we've all seen that movie where Julia Roberts was running around from household to household to get people to sign up. Are you running around like Julia Roberts trying to get people to sign up?
So I am in the very fortunate position that the class action where I'm acting for plaintiffs I was asked to be counsel. It was all the individuals were already arranged, and it's not something that I would do. All of the cases listed here, save one, I'm acting for big corporate interests who have been sued, whether it's via rail or for Bank of Montreal, for UPS, for the Dominion Insurance. for South Gobi Resources, all those I'm acting guidance for the heart pacers, all of those ones I'm acting for the defense. And
You're acting for the big, powerful, rich corporations, and yet you say in your article, class actions have changed the legal landscape and given rights to individuals that previously could not be litigated, and changed behaviors of corporations, governments, and future planning.
absolutely. And the fact, it doesn't matter which side of the fence you're on, that's a statement of fact. But I happen to also have this one case for plaintiffs for the 6 million Canadians dealing with Capital One and Amazon Web.
And this is what, data breach? Someone
Data misuse and data breach. And it was the largest bank loss of data in the history of mankind.
and of those 6.5 million Canadians, have they all signed up, or just a few people were able to form the class?
So you've hit on a very significant procedural piece. Pardon the procedural, but here you go. So one person can bring the class action. And in Ontario, it's an opt-out statute. So if I get the case certified, or somebody else gets the case certified, everybody who's named in the class is in. If they want, they then get notice. If they want to opt out, they can, but they don't have to. So they aren't named in the case, but they are automatically in. So 6 million, if I'm successful in Ontario getting the case against Capital One and Amazon Web certified, if I'm successful in doing that, then all 6 million plaintiffs are in the action, unless they decide they want out. And they've got a limited time to do that.
And my sense is that in the United States example, it's almost all contingency lawyers that take these class actions. Are you a contingency lawyer in this regard?
In this regard, yes, although there are supporting mechanisms depending on the size of the case. And if we get certified, then we will definitely look for funding. And so, yes, it is a contingency style case. It's more on the basis that if we don't get paid if we aren't successful.
Fascinating. This is going to be an interesting conversation tonight. We're going to take a break for some messages and come back in just 2 minutes with John Campion and talk about some of these specific cases and maybe get some clarity on what's going on here. Stay with us, everyone. Back in 2 minutes. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 960. It's a pleasure of mine to be interviewing again John Campion. He is a lawyer. He's an arbitrator. He's a litigator. He's got a Bachelor's of Arts, a JD Law, an MBA, an FCI ARB. What's an FCI ARB, sir?
It's a fellowship of the Chartered Institute of Arbitrators. It's sort of the international designation of those who have become and trained to be expert in arbitration.
And what's a CS?
Certified Specialist in Civil Litigation for the Law Society of Upper Canada. It's a designation which you earn and get tested every year.
And an Emeritus Bencher. What's that?
So I was elected 4 times as a governor of the profession from 2000 to 2016. As a result of being a bencher for that length of time, you become an Emeritus Bencher. And I also was president of the Federation of Law Societies for Canada, where I helped to merge the profession across the country into a single profession, at least in part, where I can appear in every jurisdiction in Canada, as can every other lawyer.
You've been counsel in over 500 trials, arbitrations, tribunal hearings, appeals, and judicial reviews, and an arbitrator in over 60 mandates. You were chair of litigation, elected chair of Fasken Martineau from 1972 to 2017, and you were ranked by Lexpert in the top 25 corporate litigators in Canada and others. And you devote yourself to the development of law across Canada and the globe in a number of public and private mandates. What a fantastic and impressive background. And last time we chatted, you told us about after all these years as litigator, you decided to do an MBA and you traveled around the world completing your MBA. So pretty impressive, sir. Let's go through some of these cases that you referenced in this. Really, I found it a very interesting article about class actions because, as I mentioned on the top, I wasn't aware that class actions were such a big issue in Canada. I thought it was more of an American thing. So a propane explosion that shook Toronto and created a fireball scene in Buffalo. What was that?
So at the top end of the city, there was a construction company which leased part of its lands to a propane company. And propane transportation and delivery and storage is governed by a provincial organization. As you would imagine, it's a highly volatile thing and it has to be done safely. So the propane company on the lands of the tenant or on the lands of the landlord uh, did truck to truck transfer. So they transferred from one truck to another, and it's highly dangerous. And it blew, and it really blew. So much so that this huge explosion that this is way up north of the 401. I could feel it where I was, and I didn't even know about the thing. I just felt this movement down at St. Clair and Yonge. And the fireball was seen all the way in Buffalo. Sadly, I think one man was killed, the operator, and a lot of property damage occurred. And they sued a whole lot of people. They sued the landowner, my client, and they sued the propane company, but they didn't sue the regulator. So I took the position before the court that they couldn't proceed without doing so. And the court agreed with me. And so they sued the regulator. Well, in the end, the regulator who had approved this illegal step paid the damages. And we fought this thing out because everybody wanted the landlord to pay. But I argued all the way to the Court of Appeal that they shouldn't and be liable for anything, and I wouldn't pay anything. This was a multi-million-dollar problem. And the reason was that if a landlord is required to pay for the activities of its tenant on every occasion, you wouldn't have any landlords because who could afford the insurance? Nobody could. So I was successful in holding that line. It was very intense. It had a whole lot of very technical, nuanced legal issues, and I held it all the way up. And while the settlement occurred under the direction of the former Chief Justice Warren Winkler, my client paid nothing. So that was how that case ended up. But it was very intense. It went on for a number of years. We had a huge series of arguments as to whether I would have any liability or not, and who else would be liable. And of course, as it turns out, in the end, there was something like 12 or 13 parties brought in because you bring in the construction people for the hoses, for the valves, for all these things that come along in these complicated negligence cases. And I, as my little landlord, held tough right through the end, and I was the only one who was successful and walked away.
The largest gold mining fraud in the history of mankind in Indonesia, known as Briax Minerals. Tell us about that one.
Well, Briax was indeed, as I have characterized it, some developers and prospectors, Canadian, found what they thought on the equator. May I quickly add, found a gold deposit. And I have to, the equator is a big thing because when you go to I went to the site after the fraud was exposed and the lawsuit for how many billions of dollars was made. And one of the main defendant was Nesbitt Burns, owned by the Bank of Montreal. And if the damages were, let's say they approximated $8 billion.
$8 billion.
Yes, sir. That's at that point in time, that's a very substantial hit for the bank. It's very, very difficult.
Still is today.
It still is today, but it would be in those days the banks were smaller. So the question is, the stock market went from pennies to $280 per share. Now they split, but just take it in total value. And there were people, because I had more lawsuits. There were individual lawsuits as well as this class action lawsuit. One of the individuals in Ottawa, they'd worked for what, $30,000 a year for the federal government. And all of a sudden they were like 10, 20 millionaires. And they changed their life accordingly. Well, when they bought the things, they were worth a penny. And at the end, they never sold it. They were advised by their auditors or their tax accountants not to sell it because the gold mining shares were as good as gold. If you sell, you have to pay tax. So they didn't sell. And guess what happened? They became valueless. These guys will never see the world the same way again. But for the actual main case itself, it was brought against a whole host of characters. And I was the lead defense counsel among about 20 and carried the case. And Harvey Strasberg and a host of other lawyers were acting for the plaintiffs. And this was the comment, because the shareholders were worldwide. We had actions across Canada. We had actions in the United States, and I was actually charged with dealing with all actions worldwide for BMO and Nesbitt Burns. And the question was number one, really our problem was, because Briax itself was sued, was there a misrepresentation by the people who were buying and selling the stock? Because Nesbitt Burns had become the senior broker in dealing with the stock market and this particular company, Briax Metals. And then the question was, well, how is it possible that this wasn't a fraud by nothing to do with the banks or Nesbitt Burns or anything like that, but by the people who developed it in the first place? Who did it? Because what happened is, and the crazy part is that they kept showing increased values of the gold, and they kept showing the deposits, and people around the world believed it. But at some point in time, they couldn't develop it; they had to sell it. So they brought in a big Canadian developer, and they went to try and duplicate the gold samples in the soil, and they couldn't do it. And in the outstanding history of this case, which I could go on forever on, the question is, who did it? Well, again, one of the lead prospectors, developers, was a guy called de Guzman. And he was celebrated here in Toronto in March of the 1997. He was brought in on a silver tray because all the prospectors meeting in Toronto are all celebrating this worldwide event of the largest gold mine in the history of Canada. And de Guzman took the credit. Well, within a very few weeks, he was thrown out of a helicopter, or jumped out of a helicopter, depending on which way you look at it, and died in the jungles of Indonesia, is the story. But who knows? And I rode that very same helicopter, by the way. Now, this is a movie. This is a number of books. This is it still remains sort of the time, the blood inquiry and the blood problems in the 90s led to the first use of these actions, but Briax was the most spectacular beginning because it was worldwide. So Briax was and is and remains a story of legendary set of issues. And I'm not saying anybody was fraudulent. I'm not naming anybody, but there was a criminal trial here in Canada, which was unsuccessful.
Against who? Against Guzman?
No, de Guzman was long dead. You can't charge a dead man. It was against the chief mineralogist, and his name escapes me right now, but he was not convicted. The man who owned the company, I don't believe he knew it was a fraud, because let's assume that you're sitting in your downstairs basement in Calgary, where he was living in his house. And I mean, that's all he had was an apartment. And someone comes up to you and says, look at that gold mine that you said gave us a little bit of money to go and look for. You have the largest gold mine in the world. Were you going to say, well, no, I don't? No, you're not going to say that.
Well, you're
so
going I went to the second and third opinions, probably.
No, we couldn't talk about it. He's the owner. He owns all the shares. They're rocketing from the worldwide money that moved through this thing. And I know that there's no doubt that some people knew about the fraud and were buying and selling and making money on the trades. I don't know who they are, but there no doubt that occurred. They're the old pros who said, well, we'll take this for a ride and get out. And they did. They took it for a ride and went out. And then there's the people who
waited too long.
Waited too long. They bought it when it wasn't worth anything, and they held it when it wasn't worth anything. But the question is, do they have any damages? So this case became very important because the council sought to impose on the system a cause of action, or a cause of action from the United States, or a doctrine from the United States called basically based in fraud. And it was basically a fraud based on a systemic fraud. And the question is, they have it in the United States, very complicated doctrine. Could they have it in Canada? And the Canadian court said no. As a result, you needed to prove individual reliance for every shareholder. Couldn't do it because class action has commonality attached to it, so that they dismissed the case early in the regime, for which I was successful. The doctrine was called fraud in the market. The question is, could fraud in the market theory be brought into Canada? And we argued it about 4 times variously, and I prevailed on that particular argument, and I prevailed therefore in the entire case. So the class action couldn't be carried forward as a result of all of this, because this was such a spectacular trouble spot for investors and for stock markets and for people who were advising. They decided to change the Securities Act. They had Tommy Allen and they had Peter Day do different reports on what to do, and they changed the Securities Act, and they, for a limited array of class actions, if you're claiming misrepresentation, which this case did, you don't need to prove reliance. So you can have a class action, they limit the damages, and they give good defenses, but the acts of Canada, right across Canada, the Securities Acts were all changed to get rid of this single problem of proving individual reliance and therefore losing class action. So it had a huge impact, and still does. It's legendary in terms of its impact across the country, both in terms of securities cases and generally just people who won and lost, and the whole extraordinary interest in people who, where there's gold and death and fraud all mixed up in the same thing. It catches your eye.
This reliance issue is kind of interesting. I'm not sure if you've been following the trial of Donald Trump in New York on valuation fraud, and one of the defenses is that there's not a victim, and so they're trying to find, even though it's obvious that he inflated the size of his penthouse, let alone the values of all of his properties. Do you have to show a victim?
No. Well, yeah, you do. Yes, of course you. In a class proceeding, the victim is somebody who suffered loss. No losses, depending on the cause of action, but in large measure, you have to have losses. In this case, the loss of the value of their shares. And so we never got to that stage because I won at the beginning and got it thrown out on the basis they couldn't prove reliance and have a class proceeding. But the damages piece would have been a long and tortured game, but they would have done that through a series of individual trials. And so the reliance piece in Trump is the lack of a victim. These people are known victims. The class members are known victims. They lost money.
Fascinating situation. We're going to take a break for some messages. We'll be back with John Campion on class action lawsuits in Canada, sort of history and what they've done and how they've changed the legal landscape in just 2 minutes. Stay with us, everybody. Welcome back, everyone, to the Brian Crombie Radio Hour on Saga 960. My guest tonight is John Campion, a very impressive a lawyer who we're chatting tonight about class action lawsuits. John, you've been chatting about Briax. You've talked a little bit about this this big explosion that I think I remember up North Toronto, and you mentioned something about this Capital One data breach case. Tell me about it, because it sounds like this is something that had 6.5 million. There's a good percentage of Canadians that have potentially had their data breached. Where does that stand? And you said we can all get $10,000 out of it. Why? Because what misuse of our data was done?
So I'm going to not. So the use of the number of 10,000, don't go down that trail, because we're a long way from that. As to whether there are any damages, but the significance, I mean, let me explain. So data has become the new currency. And when I started this case, I didn't have a sophisticated understanding of data and all of its uses, because of course it's radically shifted in the 4 years since I began this case in Capital One. And plus you had to dig, and it's not so much it's changed so much, it had already changed, but we didn't really know about it. We certainly didn't know about ChatGPT or even the potential of it. So what does ChatGPT have to do with it? Well, in order to run this vast system of information, you need unbelievable amounts of data. So the question is how do you control data? And the Supreme Court of Canada has said on several occasions that a person's confidential financial data, or any confidential data of any kind, but this is financial, it goes to human dignity. In fact, it's so serious that a breach of it can even go to the not quite, but in the category of physical damage to a person. And when one begins to speak about human dignity, it takes on a very high measure of significance. So as I began to comprehend what data was, there's in the early 90s, as data was beginning to become important, people were using computers to deal with data. Just put it in, get the information out, usually in local businesses. Then the internet came along and data could be used for commerce. And once the internet came along and data in the year 2000 or so, and could be used for commerce, then people were giving their data out into the system in order to engage in commerce. Credit cards in this case. And through the 2000s, they went from computer-based analysis through to around 2010 to machine learning. And if you deal with machine learning, what you needed before, you needed 20 times the data after machine learning became in place in 2010. And then became the whole notion of putting it onto the cloud, and data was accumulated. In this case, it was Amazon Web. And Capital One not only put it on the 6 million Canadians, but it put on 100 other million people from around the world who were their clients. So we're now talking about the accumulation of data into one place. And of course, wherever you accumulate data, if it can be hacked, it can be dangerous.
So they put it on there on purpose or by mistake?
Oh, they had a contract with Amazon Web, as I understand it. So Capital One needed
they got hacked.
Power. It did get hacked. But it wasn't the hack. The hacking brought it to the attention of the world. Of that, there's no doubt. And they faced an $80 million fine in the U.S. for doing so. Capital One did. And that's the largest fine ever given in the United States for a data breach by the regulator in the United States, with an odd name, may I quickly add. It's the Officer of Currency or some such name. But what happened in Canada was that they had applicants and those people who became their customers, but many of the applicants did not, but they kept the data. And so you've got they've kept the data and they're using it. It's not just that they're holding it, they're using it for running their businesses. And what else, I don't know. Now, these are allegations and a claim. I'm not saying it's all true. Okay, so let's make it very, very, very sure. But that's what has been pleaded. And the judge of first instance dismissed the case. And the Court of Appeal is now considering it. And let me deal with what the central issues are. Is there a cause of action for data? And there is, and it's called intrusion upon seclusion. The question is, what do you need? And the first judge of first instance said, no doubt the hacker was an intruder. The question is Capital One an intruder by keeping the data? And then there's a whole lot of other issues out there that come along. What's the responsibility for all of this from Amazon Web, who held the data? And are they negligent?
Well, when you give your data to a financial institution, aren't you counting on them keeping it secure in a secure place? And so therefore, if they are open to hacking, they're not doing their job.
So that's the allegation. And I'm being cautious here because this is before the courts and I don't want to in any way affect their position. And I also want to be very careful to protect Capital One and Amazon Web. I'm not saying any of these allegations are true. These are the allegations in the claim. We do know about the fine. We do know about the loss because they announced it themselves. That's public information. But what I don't want to do is get into the case. These are responsible organizations that are being sued. These are important individuals and the courts will decide whether there is any meaningful rights being infused in this case. But it is significant because the court is going to decide in the near future, because it heard the case and reserved in June 15th. They're going to decide what these causes of action are and where they might apply. And the intrusion upon seclusion is important, but there's also another one, and that's conversion. So conversion is an old cause. And the reason why these are important is you don't have to prove damages in intrusion upon seclusion. You get moral damages. And the case that was decided in 2012 dealt with it. So it's a very important cause of action, which the scope of it has to be properly set out. And that's what the Court of Appeal is at least going to in part do. And there's been a recent case in the British Columbia Court of Appeal after a trial, may I quickly add, against the insurance bureau and the insurer in British Columbia, which insures all the motor cars in the province. And they didn't use intrusion upon seclusion, but they did use the Privacy Acts in British Columbia to determine that there was liability and that there could be a whole assessment of damages without showing individual damage. So the whole area is very open, nuanced, and moving, and it's not settled. But so is data. I mean, when you look at the only way to have the GPT system go is they take all the data in the world. Now, it's not private data, but it's all the stuff on the internet. Have they got a right to do that or not? I have no idea. Good luck to them. So this is an important case which affects the dignity and rights of Canadians. It doesn't mean I'm right, but its significance is what are the limits on holding and using or using data for private profit and holding it in perpetuity? Can they do this? And we'll find out.
That's when you're working for the plaintiff. Is it different working for the plaintiff than the defense?
It is very much more difficult. First of all, you got huge responsibility on your shoulders. You do in either case. But 6 million Canadians are, they're not necessarily all know about the case, but they've been identified. But it's not, something. It's the one thing it's important to remember about class proceedings. They're public cases. They aren't like the normal private litigation. They're governed by an act. They're overseen by a judge. They're hotly argued. And as a plaintiff, whether you're a plaintiff in a class proceeding or a plaintiff in an ordinary action, you take the risk of formulating the case. Is it pure nonsense, or is it the best case that's ever been pleaded in the world? And you take risk because you can't do everything. You've got to focus on what will work and what will not. And when you start a case, you're telling your client this will work, and away you go. But that's a huge responsibility. In this case, it's going to determine how data is going to be treated in law and privacy. It's going to deal with the dignity of every person in the world who has data, which is meant to be confidential, or every person in Canada who's not get carried away here. It is a trans-Canadian case.
You worked on tax return system accuracy. Did you actually work for the CRA?
No, that was a private company from the United States that does systems, and they got sued for somebody alleging that their system was faulty, and that was sort of by the by. But I will say the insurance contract case is by far the most interesting in one sense, procedurally, because a case was decided without my involvement, going all the way to the Supreme Court of Canada. And the Supreme Court of Canada didn't give leave. And the Court of Appeal made a decision. 3 years later, they sued every insurer in Canada. So you had, 100 insurers, hundreds of millions, billions of dollars. I don't know what the whole thing would have been worth in the end. And I took the process decision that I would still oppose the new case in Ontario for my insurance client, which it happened as the second level of the case, along with all the 100 across Canada. And I told all the insurers that what I was going to do is that I was going to go to Alberta and argue the case and ask them to overturn the Ontario decision. I was going to come back to Ontario and I was going to ask for a 5-court bench, which is almost never given, in the Court of Appeal, overturn themselves less than 3 years on. Almost never do. And out we went to Alberta. They wouldn't criticize Ontario, but they found differently. And it's all the same clause in all the insurance policies for automobiles across Canada. I came back to Ontario. Of course, Ontario's the trial judge is bound by the Court of Appeal decision which had been made. So they dismissed my case, and I take it to the Court of Appeal. I asked Justice McMurtry, who's then the Chief Justice, to give me a 5-court bench, and he did. And I'll tell you, there are a lot of people, they thought I was full of nonsense when I said I was going to get a 5-court bench and argue this case. I re-argued the case, and we won.
Why?
Because I was right on the interpretation of the clause, which the Court of Appeal had made a mistake on. And for the Court of Appeal in 3 years' time to change their decision, because it had consequences across the country, is almost never done. That's why it's rare. So it's great
Congratulations, I
fun.
guess, in that one. That's great. We're going to
Yeah,
take a break and come back in 2 minutes, and we're going to talk about, the implications of all of this and maybe some of the personalities involved. Stay with us, everyone. Back in 2. Welcome back, everyone, to the Brian Crombie Radio Hour on Sagan and 60. I'm having a lot of fun chatting tonight with John Campion, a top lawyer, advocate, arbitrator, litigator, former chairman of Faskins, now with Gardner Roberts in Toronto, someone who's argued around the world. He says he's been to USA, Indonesia, Australia, Hong Kong, Taiwan in pursuit of justice, evidence, and strategy. Sounds like really quite the impressive and interesting career. You mentioned Warren Winkler earlier. I had occasion to be in an arbitration with him. I can't tell you about the whole arbitration process, but I found the man fascinating. And I think you said he was the Superior Court Justice, Justice of the Superior Court of Ontario, and he had these great stories of hunting and things like that. Tell me about some of the characters that you had.
Well, let me talk about Justice Winkler. So Justice Winkler, I had a trial that went on at that point was one of the longest running trials in the history of the province for 265 days, which I lost spectacularly. And Justice Winkler was the judge on it. Very painful, very painful. I might have quibbled, but I'm not. Within 2 years, I was before the same Justice Winkler in Briax. And I'll tell you, I won Briax, and I couldn't be more surprised that I won Briax and lost the earlier case. It could have well been the reverse, but it wasn't. So Justice Winkler, he became the Chief Justice of the province. There are many of the judges who become acquaintances, and you know them. You don't become friends with them, but you certainly know who they are. And of course, he was a very prominent practitioner in the labor field. I didn't know him then, but my senior, Walter Williston, did. And so Warren Winkler is a character, and he's obviously very smart, and he is a magnificent public servant in settling complex cases. And he was the one who settled the explosion case, the propane case. So he's a character, but it's more than a character. He's, one of our gems in the judicial system, by far. I want to talk a little bit about some of the early plaintiffs' counsel, and there's a number of them. Doug Elliott in human rights. He won the case dealing with gay marriage. You may remember. And
I've had him on my show talking about that case.
Yeah, and he did the blood inquiry. So Doug Elliott is a magnificent human being and a wonderful counsel. But Harvey Strasberg can't go by without being mentioned. He's a lawyer from Windsor. He was a student at Faskins before my time. And he remains a very good friend. He was on the opposite side of the Via cases, or he was on the opposite side of Briax. He wasn't on the opposite side of the Heart Pacer case, but Harvey is creative, strong, determined, and has changed the face of class actions in Ontario and across Canada. He's brave and courageous. He was a very prestigious. He was treasurer of the Law Society, which is the top position, and remains a very good friend of mine. But we did fight tooth and nail through the cases. So I can't, as the characters, there are a number of counsel who, on all sides of this equation, who are outstanding counsel, and they tend to be intellectual. And I want to name one character who no one will know about, but Robin Roddy, who's a research lawyer at Faskins, still is. He is brilliant. He is just fabulous. And so I've mentioned now some of the people that stand out in my mind, but some of my colleagues at Faskins that I worked with, one's now a judge in British Columbia called Ward Branch. He went out on his own after he helped me in Briax as a relatively junior lawyer. Another lawyer called Paul Martin, who is at Faskins. They're simply magnificent lawyers who've done tremendous work, but it requires a basic understanding of law and causes of action and process that is more acute and oftentimes magnified. And of course, they carry with it the old switch of win and lose. If you lose, you're no good. And if you win, you're a star. Well, there you go. You got a lot of these issues. And as counsel, you got to brave it out and carry on.
Tell me
So
about the implications of
fabulous.
your cases. You said that in your article, these cases have major international corporations sued by millions of claimants and significant novel changes in process and most significantly principles of law in numerous areas of securities, negligence, occupiers liability, intrusion upon seclusion, breach of trust, breach of fiduciary duty, breach of privacy and security statutes, conversion, strict liability, misrepresentation, etc.
Right. So let me start off with, when you start a class action, you've got to get it certified. And to get it certified, you got to meet 5 criteria. And one of the criteria is, do you have a cause of action? Second one is there identifiable class? Thirdly, are the issues common? Because if they're not common, you can't have a class action. You can't have 15 cases inside one case. You've got to have, everybody has to have at least one common issue. And then there are some other pieces I won't bother to deal with. The cause of action piece, what I've listed here in these causes of action, are the things that arise. Negligence would be the most obvious one and the most common one. A securities case and misrepresentation would be common. The Briex case was a misrepresentation case. The intrusion upon seclusion is the Capital One case. And on it goes through these various causes of action. And they say, well, it doesn't apply in these circumstances, therefore dismiss the case, which is what I did in the Briex case. In other cases, you argue it out. In other cases, it's perfectly obvious, but they say there's no commonality in these pieces. So as you begin to deal with these cases, you've got to, in effect, it's almost as if you're arguing the end result at the earliest possible stage. And you can win and lose greatly, because oftentimes after they're certified, they settle. They don't always. There's not been very many class action trials, but the economic pressure of having them certified, or the economic reality, leave aside the pressure, means that defendants have to sit down and say, is it time for me to say goodbye? Well, in propane, I didn't. In Briex, I didn't. In the insurance contract case, I didn't. I kept winning them at an early stage. But in other cases, the Hardpacer case, it did get certified. We settled. Not much money. So be it. The train crashes for Via Rail, we settled, but not much money. So the process, the importance, I think that the importance is, in the securities case for Briex, we caused changes across Canada in the Securities Act, how the whole system will operate from now on until whatever time they might want to change it again, which I don't think they will. That's a huge impact of one lawsuit. The idea of having people personally recover and feel it, and I want to deal with one very important case, and that was, it's not listed here, and that's dealing with Bernardo's. Bernardo's was a children's charity and is the second largest children's charity in the world in Great Britain. Dr. Bernardo in the 1800s saw the plight of young people sitting on the streets of London, where they were dying for any number of reasons, left abandoned, and took them in one by one into the Bernardo system. And he then fundraised to help care for these children. There were so many of them that they began to find places to have them go to Canada, Australia, some to the United States, where they were sent over. Now, 1/3 of Canadians are connected genetically to Bernardo children. My mother was born on a farm, and she mentioned from time to time, which I never understood, called, not farm boys, what did they call them? Homeboys. Called them homeboys. And they went and worked on the farm. They lived with the family, and they went to school, and then they went off on their way. Well, these were the Bernardo children. And they sued, Mr. Vanel, one of the Bernardo children, sued Bernardo's for systemic abuse. And Harvey acted for Mr. Vanel, Harvey Strasberg, and I acted for Bernardo's. And I was of the view that they couldn't make the case out, and it wasn't right, because they had saved these people, not destroyed them. But they've removed them from their family, and there's all these other kinds of issues that went on. Well, I've forgotten, I think we settled for costs in the Bernardo case, but it was so fascinating because I had to review the entire system of the Bernardos sending children across over the seas. And it was the subject of a parliamentary inquiry in England, of which it was very critical of all these sending societies, because the sending societies didn't just include Bernardos, included YMCA, included churches, included all kinds of people. But the world is populated with these people. It was a British Empire thing. There we go.
John Campion, thanks so much for joining us. And chatting with us about class actions. Your final sentence in your article was class actions have changed the legal landscape and given rights to individuals that previously could not be litigated and changed behaviors of corporations, governments, and future planning. Thanks very much.
Pleasure. Thank you.
That's
very
our show
much,
for
Brett.
tonight, everybody. Thanks for joining. I remind you, I'm on every Monday through Friday at 6 o'clock on 960 AM. You can stream me online at www.saga960am.ca. Good night.